Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, Perspectives, Problems, and Skills. 9th edition. Chapter 10. Narrated by Omar Mohsen Ibrahim Fouad. Legal Writing. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to illustrate the importance of legal writing in the practice of law, summarize the preliminary steps for all legal writing assignments, employ the techniques of proofreading on your own writing, demonstrate the dangers of copy and paste writing, distinguish between the different kinds of letters in a law office and their standard components, write appropriate email posts, value the role of software and form books in the drafting of instruments and pleadings, list the major components of an appellate brief, demonstrate general guidelines for achieving clarity and precision in all categories of writing. What if you were asked to proofread an important contract that your office prepared for its new client, Brighton's Software and Computer Technology? The contract is a business venture startup with Social Tech LLC, a new social media site for individuals interested in connecting with other entrepreneurs in the tech world. It promotes online innovation and social inclusiveness as part of its draw for 18 to 30-year-olds. You have been given a summary sheet of all the critical terms and conditions of the contract, and you are asked to proofread the document, including checking grammar, spelling, and punctuation. Your supervising attorney made a point to tell you that the client wants a non-competition clause for 2 years and absolutely refused to indemnify Social Tech for any negligence or lawsuits that may be claimed by any third party. Other terms and conditions require Social Tech to provide quarterly financial statements and semi-annual updates of membership. You have 24 hours to review the document before presentation to the client for signature. Given that you do not have much time, you perform a spelling, punctuation, and grammar check using Word. After correcting highlighted areas, you review the document again. You turn in the contract, letting your supervising attorney know that the proofreading assignment is complete. The contract is presented to the client for review. The next day, your supervising attorney comes into your office and closes the door. Looking upset, the supervising attorney tells you that the indemnification clause did not contain the words "will not indemnify," making the client irate. They almost fired your firm from the project. You can't understand what happened as you used the software spelling, grammar, and punctuation check feature. The facts above highlight the importance of properly checking your work when presented with an assignment. Relying on software programs solely to review your work is not always reliable or foolproof. As we will examine in this chapter, there are several critical steps in the legal writing process. Those steps include drafting, editing, proofreading, and more than likely repeating that process again and again until you get a final product with which you are satisfied. Oftentimes we review our work and miss errors that should have been caught or simply have read the document too many times that the errors do not readily reveal themselves. This process is not a guarantee, but there are steps you can take to guard against errors, such as the one found in our fact pattern. This chapter will introduce you to legal writing and teach you how to master such tasks as drafting, editing, and proofreading legal documents. This chapter will provide mechanisms to have confidence and success in drafting legal documents and engage the skills required when asked to prepare a legal document by a supervising attorney. Legal writing, like legal research and analysis, is a skill mastered the more you do it. We will start at the beginning of the process and build on those skills throughout this chapter. 10-1 Introduction. Legal writing is an important skill in the practice of law. To a large extent, the legal profession lives by the written word. Any important task of an attorney, judge, or legislator is almost always heavily documented in writing. Everyone is reluctant to rely on oral communication alone. Consequently, a busy law office generates a vast quantity of paper, even in the age of digital communication. Once documents are prepared on a computer, they are often printed as a hard copy, i.e., important example, on paper. Competent attorneys tend to be very particular about how something should be written. You need to learn the style of your supervising attorney, such as by reading documents they have written in prior client matters. A paralegal who works for more than one attorney should not expect that they would all have the same style. This can sometimes be disconcerting. What pleases one attorney may trouble another. Before examining ways to cope in this environment, it is important to understand that the phrase legal writing can be used to describe different tasks: preparing documents that require legal analysis, preparing documents that require legal research, making sure that legal documents conform to special formats, using clear and precise language to communicate effectively in any legal document. Although these four tasks are often interrelated, our primary focus in this chapter will be the latter two tasks: an introduction to the formats used in some of the documents commonly prepared in a law office, and an overview of important general communication techniques that can improve writing in any legal document. Legal analysis is covered in Chapter 8, whereas legal research is covered in Chapter 9. We begin the suggestions that can be helpful for all writing assignments in a law office. 10-1A Initial Steps when receiving a writing assignment. When you are given a writing assignment, there are certain steps you should follow to ensure you understand what to do. One of the hardest things for many people to do is ask questions. When they do not understand something or fail to seek clarification after an assignment is begun. The first lesson to always keep in mind is that asking questions is important in the process. What is clear to the person presenting the assignment may not be clear to you. Oftentimes, the attorney is familiar with the topic, so they skim over necessary details, or they are in a hurry and fail to provide sufficient guidance to get the assignment done. That leaves you in limbo and sometimes working aimlessly, possibly spending hours going down the wrong path. To avoid these pitfalls, consider the following guidelines when beginning a legal writing assignment. 1. Obtain basic instructions on the assignment you are given. What are you asked to write? Letter, memo, etc.? Who will be reading it? Who is the audience? When is it due? Does it have priority over other assignments? If you have assignments from different supervisors, ask these supervisors to establish the priorities. Don't guess. Is your time working on this assignment billable? If so, to what clients or accounts? What format should you use in the document you will be preparing? For example, what font and point size should you use? What resources can you use? For example, if your assignment requires legal research, can you use fee-based electronic research, like for example, Westlaw, LexisNexis, Fastcase, or another service? See chapters 9 and 11. Will the supervisor or anyone else in the office be available to provide feedback on a complete or partial draft of the assignment before the final product is due? There are some of the initial questions you should be asking. These are some of the initial questions you should be asking yourself when you are assigned a legal writing project. These questions should be your initial checklist for your assignment. 2. Find out if the office has its own style manual. Someone in the office may have collected general format instructions for different kinds of writing. The office often prepares. Everyone may be expected to follow these instructions. The style manual may also include sample documents that conform to these instructions. If such a manual exists, it may be in a notebook or in a computer database. Quick tip: if your assignment involves preparing a court document, determine if there are any special court rules that must be followed in preparing the document you are assigned. Most court websites have their document style rules posted. 3. Find out if the office uses any published texts as guides for commonly prepared documents. Is there a bar practice manual that is considered the standard for the procedural and substantive area of law involved in the assignment? Have courts in the state written a style manual, like for example, Oregon Appellate Court's style manual? Are other guides favored by your supervisors, like for example, Brian Garner's The Red Book, a Manual of Style? 4. Ask your supervisor or others where in the office you can find copies of documents on other cases that you may be able to use as a model or guide for the document you are asked to prepare. This is important to remember. Do not reinvent the wheel. Chances are there is someone else in the office who has had a similar assignment. Do not start from scratch if you do not have to. 5. Once you have a model, adapt it to the specific facts and instructions of the writing assignment you are given. 6. For complex assignments or writing tasks that you have not performed before, seek early feedback before submitting the final draft. For example, prepare an outline of the document and ask for feedback on the outline to make sure you are on the right track. This will not be needed for relatively simple documents or ones that you have prepared often in prior assignments. Remember to ask questions or seek clarification. You do not want to get too far in an assignment only to learn that you have misunderstood what is expected. 7. Carefully and regularly proofread to make sure there are no grammar or spelling errors in your final draft. This cannot be overstated. Proofreading is an essential component of legal writing. There are self-proofreading techniques that can assist in the process. Nothing is 100% foolproof. but learning these techniques will assist in catching most errors or mistakes in the document. Quick tip: before turning in an assignment to your supervising attorney, be sure you proofread the document and then proofread it again. Turning in an assignment with simple spelling, grammar, and punctuation errors often shows you were not diligent in preparing your assignment. Errors and mistakes will occur, but by carefully proofreading, those will be minimized. 10-1B Proofreading Techniques. How to proofread your own writing. Proofreading your own writing is an example of self-editing. This task is critical because it is very easy to overlook our own typos, spelling errors, grammar errors, and format inconsistencies. For many of us, the more familiar we are with the writing, the more likely we are to overlook problems in the writing. Proofreading techniques. Do not do the proofreading immediately after you finish drafting the document. A short or long break, if possible, will help you look at the document with fresh eyes. If you drafted the document on the computer, print a draft of the document and do the proofreading on the hard copy of the draft. Do this in addition to proofreading it on the screen. If possible, email the document to yourself so that you can proofread it as an email post. Quietly read your text aloud to yourself. This may turn up errors that were overlooked by silent reading and rereading. Make a copy and read the document to another person who will follow the text as you read. Reverse the steps. Have the other person read the document as you follow the text that is read from your copy. On the computer, temporarily change the font and point size of the document. Also, change the margins. If the document is single-spaced, temporarily double-space it when you proofread it. Reading the document with these changes may help you identify errors. On a hard copy, reread it with a ruler or a blank sheet of paper beneath each line. Read your text backward. This might help reveal glaring errors in spelling or punctuation, even though you are not reading for content. As you read, tap every word and punctuation with your finger or the eraser end of a pencil. For the same effect, use a felt pen to place a red dot over every word and punctuation mark as you read. Slowing down your reading this way can be beneficial. Spell checkers in word processors, refer to Chapter 11, are sometimes helpful. Be careful, however, in using a spell checker. It will tell you if you misspelled the word there, but it more than likely will not tell you if you should have used the word there. If you ask your spell checker to check the sentence, do I sense that you are afraid? You would be told that there are no spelling errors, although it should have read, do I sense that you are afraid? Spell checkers are usual, but they cannot check the meaning or proper use of correctly spelled words. If you have grammar checking software, use it even though it may be able to catch only basic grammatical errors. Popular word processing programs such as Word have built-in spell check and grammar check programs. Proofread the document more than once. In our facts at the beginning of the chapter, it appears that we had a proofreading issue that more than likely would not have been caught by a spelling and grammar check program because we had a critical missing word. The sentence should have had the word not in it, where it should have said will not indemnify. Spelling or grammar checks would not have caught the missing word. The lesson is not to rely solely on computer-generated systems to identify spelling, grammar, and punctuation errors. In this instance, it would have been incumbent on the legal professionals, attorneys, and paralegals to carefully review the document and make sure the critical provisions were included. But there is no real solution to this issue other than carefully reading the document. Make notes of the critical terms, conditions, or language needed in the legal document you are drafting, as that may make it easier to review when proofreading the final product. Analyze this. In a case you are working on, the word time card is repeatedly used. Is time card one word or two words? Time card. Word spell check does not correct time card. How would you determine which is the correct version? 10-2 Dangers of copy and paste. Today it is relatively rare for people to write with pen and paper. It does happen, but writing with computers, tablets, and laptops is far more common. The major word processors, Word, Pages, WordPerfect, that we will discuss in Chapter 11 substantially increase the efficiency and speed of drafting, editing, and finalizing what we write. There are, however, dangers that must be avoided. The first danger is plagiarism, which is passing off someone's original ideas or expressions as your own, as our own. It is very easy to go online and find text that is relevant to what we are writing. The text can be reports, blogs, essays, studies, etc. With little effort, we can highlight the text, copy, cut it, and paste it in our own writing so that it appears as if that text is our own. It isn't. To avoid plagiarism, cite the sources of the text you want to use. See Chapter 9 on citation. In some instances, however, citation is not enough. Copyright law may require permission to use the text. We are entitled to the fair use of portions of someone else's work, particularly if we are not writing for a commercial purpose. Furthermore, some written works are in the public domain, meaning that permission to use is not needed. Yet, even if permission is not required, the failure to cite the source constitutes plagiarism. Many colleges and other schools are so concerned about plagiarism that they use sophisticated software to detect it. They scan student writing into the software and quickly obtain a report on whether the writer may have plagiarized. And as we saw in Chapter 9, artificial intelligence, AI, through the use of ChatGPT, is now presenting even more challenges to detecting plagiarism, fake citations, and research. As we saw in Chapter 6, there are ethical rules against falsifying documents. One way to falsify a document is to allow readers to think that someone else's idea or expression is our own, when in fact it isn't. In short, don't misrepresent anything that you write. The second danger of copy and paste writing is style. Assume that George Smith finds a few sentences or paragraphs on a website that are highly relevant to the theme of the paper he is writing. Assume further that George wants to use this text without citing its source. He wants the reader to think that all of the ideas in his paper are his own. He highlights it, copies it, and drops it in his paper. He then makes a few word changes and tries to conform the format of the online text to the format of what he is writing. For example, if the font of the text in the website is Times New Roman 10 point, and George's paper is using Courier New 11 point, he changes the web language to Courier New 11 point. Such changes, however, are usually not enough. Experienced readers say that it is relatively easy to detect the presence of text from other sources. To a trained eye, the style of someone else's writing is noticeably different from our own style despite efforts despite efforts synchronize the styles. Consequently, the ethical and safest course to follow is to cite what you want to use in your writing and to avoid using copyrighted material without permission. Quick tip: when aligning the font and text size, when copying and pasting a passage into a document, in Word you can right-click the cursor and icons will appear that allow you to change the font and text to align with your original document text. 10-2A Types of legal writing documents used in the legal profession. Most of the legal writing in a law office falls into the following categories: traditional letters, emails, instruments, pleadings, memoranda of law, appellate briefs. Each form of legal writing has its formats and, in many instances, court rules that must be followed in the drafting of the document. Before you begin a legal writing assignment, know the legal rules for drafting the document you are assigned. 10-3 Letter writing. First, we examine traditional letters, those that are sent on paper. A law office sends out different kinds of letters: cover letter, transmittal letter, demand letter, informational letter, status letter, confirmatory letter, opinion letter. There is overlap in these categories because a single letter may seek to accomplish more than one purpose. Most business letters or legal correspondence have standard components. Those standard components are a guideline to follow when tasked with writing a legal letter. 10-3A Standard components of many business letters. Heading. The heading at the top of the letter contains the law office's letterhead, usually pre-printed and centered. The letterhead identifies the office by full name, street address, phone number, fax number, website, and email address. Attorney names are also pre-printed on the letterhead. Online exercise. In your jurisdiction, determine if it is permissible to add a paralegal's name to the letterhead of the law firm. Date. Give the full date, month, day, and year the letter will be sent. It is often placed flush left at the left margin or centered under the heading. Flush left means aligned along the left margin. This is stylistic and should be inquired about as to where your supervising attorney prefers to insert the date in a letter. Method of delivery. There is no need to indicate how the letter was delivered if the sender uses standard mail via the U.S. Postal Service. The sample letter in Exhibit 10-1 uses standard mail. If, however, another method is used, it should be indicated under the date flush left or directly over the address. Options include in-person delivery via hand delivery, special handling via certified mail, facsimile, overnight carrier via FedEx, email, etc. Quick tip: if you are sending the letter certified mail or express delivery such as FedEx, be sure to add in the tracking numbers after the type of delivery. This will alleviate any confusion as to matching the tracking number to the receipt of the letter. Analyze this. Why is it important to add in the delivery tracking information in a letter? What could the consequences be when it is omitted? Recipient. Give the full name, title, and address of the person who will be receiving the letter, the addressee. It is often placed close to the left margin, flush left. RE. A reference regarding line RE is a brief statement that indicates the case or matter to which the letter pertains and occasionally the major theme of the letter. Example, R.E. Henderson vs. Jones, CIV 03.179. Request for extension of time to file responsive declaration. RE means concerning or in the matter of. RE is short for in RE. The reference line is placed either 1 at the left margin, flush left, after the address of the recipient and just before the salutation, or 2 at the right margin opposite the address of the recipient. The example in Exhibit 10-1 uses the first option. Salutation. Here you address the recipient. Dear, a colon follows the name of this person. If they are a doctor, professor, or important public official, use their title. The salutation starts at the left margin, flush left, on the line under the address. Be sure if you are addressing a judge or the court, you check the proper way to correspond. Body. The body of the letter often includes identification line. In the first line of the letter, let the reader know who is sending the letter, unless this is already obvious to the recipient because of prior contact. Purpose line. Shortly after the identification line, briefly tell the reader the main purpose of the letter. Request line. If you are seeking the recipient to do something, include a specific request line that makes this clear. Elaboration. As needed, explain why you are writing the letter. Courtesy conclusion. As the end of the body, include a final courtesy paragraph. It might say something like, if you have any questions about this matter, please do not hesitate to contact me, or thank you for your consideration in this matter. Closing. Close the letter with a complimentary close, such as sincerely or very truly yours. Informal legal letter writing, stay away from informal closings such as best or regards. Next comes space or a signature, followed by the name and title of the signer. As we saw in Chapter 6 on ethics, when non-attorneys sign letters, their title should clearly indicate their non-attorney status. The titles paralegal and legal assistant comply with this ethical obligation. Titles such as CLA, CP, RP, PACE, and PP, when used alone, do not because they give no clear indication that the signer is not an attorney. Copies sent. If you are sending a copy of the letter to someone, indicate this by saying CC, followed by the name of the person receiving the copy. CC stands for carbon copy. This abbreviation is still used even though carbon is seldom the method used today to make copies. Suppose you do not want the recipient to know that you are sending copies to others. On the recipient's letter, you say nothing about copies. On the office copy of the letter, say BCC, blind carbon or courtesy copy, followed by the name of the persons receiving the copies. In this way, only your copy of the letter indicates who received BCC copies. The letter sent to the primary recipient is silent, blind, on this point. This also works with email messages. Beneath the CC box in your email program, you will find or you can add a BCC box. The main recipients of the message will not know the names of anyone entered in the BCC box. Enclosures. If you are enclosing something with the letter, say ENCL. If enclosing more than one item, say ENCLS. Some use the entire word enclosures. That is a matter of style. Initials. If someone else prepared the letter for you, place your initials in capital letters, followed by a colon. and the initials in lowercase of the person who did the typing or preparing. The sample letter in Exhibit 10-1 contains these components: specific types of legal letters. A cover letter, also called a transmittal letter, tells the recipient what physical or electronic items, like for example, pleadings, photographs, are being sent and often the reason for sending them. The list of what is being sent should be detailed. If a response is expected, it should be clearly stated. For example, enclosed for your records are the following: a copy of the defendant's answer, dated May 3rd, 2024, filed with the court on May 5th, 2024. A copy of your response, a copy of our response to the answer, dated May 18th, 2024. Also enclosed, a letter of authorization that allows us to obtain your confidential employment records from the personnel department. Please read the letter of authorization, sign and date it, and return it to us. We will need it before May 30th. If you have any questions, don't hesitate to call us. A demand letter is an advocacy letter that asks the recipient to take specific action, like for example, pay a debt owed to the client, or to refrain from taking specific action, like for example, not to terminate the client. The letter will often tell the recipient that the office represents the client, specify what the recipient is being asked to do or to refrain from doing, present essential facts and legal principles that support the demand. If the recipient is a non-attorney, citations to authority are relatively rare, except when a single statute or regulation is central to the demand. A demand letter seeking the collection of money must conform to the Fair Debt Collection Practices Act. For example, the letter must not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. An informational letter provides information to the recipient, seeks information from the recipient, or both. See Exhibit 10-1 for a sample informational letter. One category of informational letter is a status letter, written to a client to inform them of what has happened in the case thus far and to indicate what next steps are expected. Exhibit 10-1, example of an informational letter. Analyze this. Determine the components of a demand letter that is in compliance with the Federal Fair Debt Collections Practices Act. Prepare a draft letter demanding the payment of a $10,000 debt on a credit card. In a confirmatory letter, you confirm that something important has been done or said. Examples: This is to confirm that you have agreed to accept $5,000 in full settlement of the contract dispute between. Thank you for coming to the office on Tuesday to discuss the extension of insurance coverage for the employees in the southeast region of your company's operations. I want to state my understanding of what took place at the meeting. Please let me know if the following summary is consistent with your understanding. This kind of letter is important because it provides written confirmation of matters that might be subject to misunderstanding. With the passage of time, it is also good It is also a good way to provide a record for the file and to prompt the recipient to voice any disagreements they may have with the contents of the letter. In an opinion letter, the office writes to its client to explain the application of the law and to advise the client what to do. Giving such advice constitutes the practice of law. Opinion letters try to clarify technical material. Unlike an appellate brief or legal memorandum, the opinion letter does not make extensive reference to court opinions or statutes. The client's need is for clear, concise, practical advice. 10-4 Email writing. A common form of communication in the legal profession is email. With that form of communication comes unintended consequences of which you should be mindful. Although it appears to be a less formal method of communication, as legal professionals, we must be cognizant that every communication may have legal consequences, and thus we must stay away from being informal when using email. This may be difficult as email inherently tends to lend itself to informality, but remember the context in which you are sending emails. It is work-related. Here are some important guidelines when writing emails. Find out what policy the office follows on email communications going out of the office. What can and cannot be done in emails. Are you allowed to send and receive personal emails on the email system of the office? When sending emails, what format should you use? For example, is there a standard signature line that prints the name of the office? If the email contains information about a case, it is probably confidential information. Have explicit permission from your supervisor on whether you can include such information in an email. Find out if the office requires emails to be encrypted so that they go out in a code and can be read only by people with special software. Be aware that emails are not private, even those you are allowed to send on personal matters. Whatever is sent on company email systems is company property. Write a clear subject line to indicate what the email is about. Introduce yourself and state the purpose of the post, like for example, to request something, at the beginning of the message. If the message is long, the last paragraph should repeat the request. In general, avoid informality. For example, do not use breezy abbreviations such as BTY, by the way, or IMHO, in my humble opinion. Of course, avoid emoticons or emojis, such as the smiley, or treat emails with the same seriousness as a business letter to a stranger. Avoid using special formatting features such as underlining. The recipient may not be able to read them on their email system. Address the recipient professionally with a formal salutation followed by a colon, like for example, Dear Mr. Foley, unless the email is to someone you know well and is comfortable with first name use. Use correct spelling and grammar. If the email program has built-in spelling and grammar checkers, use them, but recognize their limitations. Close the post by typing your full name and title. The title should indicate non-attorney status, like for example, paralegal. Because tone can't be heard in an email, there is a danger that anything strongly felt would be misinterpreted. When we speak, we rely on voice inflection and pace to communicate nuance. Doing the same in writing is very difficult. Caution, therefore, is needed. Do not write in all capitals or bold words for emphasis. All caps reads as if you are shouting. Avoid long sentences and long paragraphs. They are difficult to read on the screen. Use gender-neutral language, like for example, police officer rather than policeman. When you reply to an email, do not leave out the message thread. Your response should appear above the message that was sent to you. Most email programs have an auto address feature that suggests names once you start typing any letter. Although convenient, there is a substantial possibility of the email going to unintended recipients. See Chapter 6 on the ethical issues that result from the wrong people seeing or hearing what is said. Such mistakes can be a breach of confidentiality and result in the loss of the attorney-client privilege. The problem is most serious when the email is going to more than one person. You can get distracted as the auto address feature selects people it thinks you mean. Hence, before you hit the send button, say the name of each addressee aloud at least twice. Do not hit the send button after composing an angry email. Let it sit for a few hours, or better yet, let it sit overnight. When cooler heads prevail, you may decide not to send the email or tone down the language. A way to avoid being tempted to hit the send button is not to enter the names of the recipient of the email at the start. Read the entire email twice before you hit the send button. If you have time, send the email to yourself before you send it to the addressee. Reading the email that comes back can be an excellent proofreading technique and a way to rethink the way you phrased and organized the post. Don't infect the office. Be suspicious of attachments sent to you. This includes attachments that appear to come from someone you know. An attachment might contain a virus. The sender may have captured someone's address book and sent the infected attachment to everyone on the list so that it appears to have come from a person on the list. Find out what virus protection the office uses for attachments. Include a copy of the message to yourself as a BCC. Quick tip: when sending client emails, add at the top of the email attorney-client privilege or work product privilege. This will assist in maintaining the attorney-client privilege, especially in the litigation context. 10-5 Instruments. An instrument is a formal written document that gives expression to or embodies a legal act or agreement. Examples of instruments include contracts, deeds, wills, leases, and mortgages. Paralegals who work with instruments are often called transactional paralegals. Instruments are seldom drafted from scratch, particularly in law offices that have many clients with the same kind of case. An example is a real estate practice where deeds, mortgages, leases, and related documents are often prepared. Most attorneys prefer to start with an already prepared document or form that can be adapted to a current client, then to start with a blank sheet of paper or blank computer screen. Form books and document assembly software programs provide useful templates and forms. A template is a file containing text and a format that can be used as the starting point for creating frequently used documents such as instruments and pleadings. This output is then adapted to the facts of particular clients. Alternatively, the office can adapt documents already in its own computer files from prior client cases. Software programs can make needed adaptations with relative ease. A pitfall in using a template or sample document is that you miss information contained in a previous document when drafting the new document. Typical errors include the use of pronouns such as he, she, it, their, them, or they. Also, prior clients' names may show up in the red drafted document by mistake. In real estate documents, legal descriptions may be in error because of adapting a previously used form or sample document. Spelling, grammar, and punctuation checks may catch some of these errors, but not all. Consequently, pay close attention to details when adapting an instrument or transactional document. Think of our facts at the beginning of the chapter where an important word was missed in a transactional document. Proofreading is critical with any legal document and can have devastating results when we work too quickly. Missing important edits. Social media. Social media and legal writing. There is no doubt that social media is a form of writing, and, depending on the site or medium, may constitute legal writing. That means that some social media writing may have legal consequences. A simple post on Facebook or Instagram or a tweet, IM or SM, may seem innocuous, but may have legal consequences, intended or not. We discussed blogs in previous chapters and are an excellent source of information, but an attorney who used social media as a blogger was disciplined by the Wisconsin Supreme Court in the case of in the matter of disciplinary proceedings against Christine A. Peshek, 2011 WI 47798, NW2D 879, 2011. Peshek was disciplined by both the Illinois and Wisconsin Supreme Courts because she blogged about her clients and made derogatory comments about judges. By doing this, she violated her duty of confidentiality and was suspended from the practice of law for 60 days by both courts in different years. What was particularly disturbing about Peshek's actions, especially directed toward her clients, was that she provided sufficient information in her blog that identified the clients and the judges as well. Peshek claims that she started the blog to vent her frustrations at being a public defender and believes her blog did not compromise any of her clients' confidences. What this case reminds us about writing as a legal professional is that we are held to a higher standard than many other professionals. We cannot use social media through whatever source to circumvent or violate our codes of ethics and the duties we owe to our clients and, in turn, the judiciary. Having such a public social media presence is often informative, but can also be destructive, as we see in the Peshek disciplinary proceeding. Although the action taken was against a lawyer, there are instances when attorneys are responsible not only for their actions, but those they supervise. It is seemingly difficult to stay away from the use of social media in today's technology-driven environment. But just like this chapter instructs to pause before you hit the send button on an email, you should pause before you post information on social media when it has an indirect or direct relationship to the legal practice in which you work. Changing names of individuals or attempting to mask facts to divert from the real cases are simply a facade, and, as most realize, it is not that difficult to uncover the real parties referenced in a blog that posts legal information. Think twice before you post or write commentary on social media, as what you do may have legal consequences. 10-6 Pleadings. A pleading is a formal litigation document filed by parties that state or respond to the claims and defenses they have against each other. The major pleadings are the complaint and the answer to the complaint. As indicated, pleadings like instruments are seldom drafted from scratch. Numerous sample pleadings can be found in form books and software programs. Law offices make extensive use of such samples for adaptation to the facts of current clients. Again, it is important to pay close attention to details when drafting pleadings because prior names can accidentally resurface in the newly drafted document. 10-7 Memoranda of Law. The word memoranda, memo, can mean a short note or a written record of a transaction. It can also mean memorandum of law or legal memorandum, which is a written explanation of how one or more rules might apply to the facts of a client's case. See Chapter 8, where you will find an overview of the different kinds of memos, along with sample memos. Also covered in Chapter 8 are the phrasing of legal issues and the application of court opinions in memos. 10-8 Appellate Briefs. As we saw in Chapter 8, the word brief has several meanings. Case brief. A brief is a summary of a court opinion that consists of 10 parts. Citation, parties, objectives of the parties, theories of the litigation, history of the litigation, facts, issues, holdings, reasoning, and disposition. To brief an opinion is to identify these 10 parts. A brief is your own summary of the opinion for later use. You cannot apply an opinion unless you know how to brief it. We covered briefing cases in Chapter 8. Trial brief. A trial brief has two main meanings. First, it is an attorney's written presentation to a trial court of the legal issues and positions of their clients, also called trial memorandum. Second, the phrase can mean an attorney's personal notes on how they will conduct a particular trial. The notes often placed in a trial notebook will relate to the opening statement, witnesses, exhibits, direct and cross-examination, closing argument, etc. Appellate brief. An appellate brief is a document that a party files with an appellate court and serves on an opponent. In the brief, the party presents arguments on why the appellate court should affirm, approve, reverse, vacate, cancel, or otherwise modify what a lower court has done. A main focus of the appellate brief is on the claimed errors made below by the lower court. The appellate brief is one of the most sophisticated kinds of legal writing. If the office prepares many appellate briefs, extra copies might be stored in its brief bank, where they can be easily accessed to determine whether they can be adapted for future similar cases. The opening brief that is submitted is the appellant's brief. The appellant, also called the petitioner, is the party initiating the appeal because of disagreement with a decision of a lower tribunal. Then the appellee's brief is filed in response. The appeal is taken against the appellee, also called the respondent. Finally, the appellant is often allowed to submit a reply brief to counter the position taken in the appellee's brief. Occasionally, a court will permit a non-party to the litigation to submit an appellate brief. This is referred to as an amicus curiae, friend of the court, brief. The amicus brief presents the non-party's view on whether the appellate court should affirm, reverse, or otherwise modify what the lower court has done. See Exhibit 10-2 for the cover page of an amicus brief filed with the U.S. Supreme Court. Exhibit 10-2, cover page of an amicus brief to U.S. Supreme Court. Front cover, title page of an amicus brief submitted to the U.S. Supreme Court. Not all appellate briefs have the same look. Court rules often specify the structure or format the brief should take, the print point size of the text, the maximum number of pages or words that can be used, the number of the copies to be submitted, the color of the paper that must be used for the title page, whether the brief can be submitted online as a PDF file, etc. Courts expect briefs to be properly thought out, adequately researched, and arguably have merit. The attorney in Nachbar vs. AM Transit INS CO 300 AD 2D 74752 NYS 2D 605 NY APP DIV 2002 drew the ire of the court for filing briefs that were lacking any legal substance. Nachbar tells us what not to do. Order of the Court, a case study. Nachbar vs. AM Transit INSCO, Appellate Division of the Supreme Court of New York, First Department, 300 AD 2D 74752 NYS 2D 605 NYAPP DIV 2002. Nachbar vs. AM Transit INSCO involves an attorney who filed meritless actions along with briefs that were wholly inadequate and insulting to the court. The attorney was sanctioned. Nachbar's counsel filed a personal injury claim against American Transit Insurance for a car accident in which he was injured. The insurance company offered to settle for the policy limits, but Nachbar's counsel believed he was entitled to more than the policy limits based upon meritless causes of action. The trial court dismissed the case, but counsel filed an appeal. Counsel's actions incensed the court, especially finding that the written documents he filed were utterly useless motion papers, including an insulting letter directed at opposing counsel. The sanctioned attorney had a history with this court. What the court particularly found mind-boggling was a 4.5 and 3.5 page appellate briefs submitted by plaintiff's attorney, completely devoid of relevant discussion, are vividly reflective of the appeal's utter lack of even arguable merit. The court continued its ire by stating that the attorney repeatedly insulted opposing counsel, made accusations against the court, and seriously mischaracterized the record and made no reference to recent adverse authority. The latter was particularly egregious. The result was that the attorney was sanctioned by the court for his behavior. Discussion questions. Review Nachbar's vs. AM Transit INS. What prior facts led to the court's decision? Why did the court admonish the attorney for failing to cite adverse authority in his brief? What sanctions did the court impose, and were they a proper exercise of the court's authority? (10-8A) The structure of an appellate brief. Caption: Table of contents with point headings. Table of authorities. TOA. Statement of jurisdiction, issues or questions presented. Standard for review. Statement of the case and statement of facts. Summary of argument. Argument conclusion. Certificate of service and court affirmations. Appendixes, if needed. Caption. The caption of an appellate brief states the names of the parties, the name of the court file number or docket number of the case, and the kind of appellate brief. The caption goes on the title page, i.e., important example, front cover of the brief. The lower court citation is often included in the caption as well. Table of contents. The table of contents is an outline of the major components of the brief, including point headings and the page number and the brief on which each component begins. A point heading is the party's conclusion it wants the court to adopt for a particular issue. Every word in a point heading is in capital letters. Point headings are printed in the table of contents and later in the body of the appellate brief itself. The function of the table of contents is to provide the reader with quick and easy access to each portion of the brief, because the page numbers will not be known until the brief is completed. The table of contents is the last section of the brief to be written. Exhibit 10-3 is an excerpt from the brief of the respondent appellee. It illustrates the structure of a table of contents that includes the point headings as part of the argument. Exhibit 10-3, Table of Contents with point headings in an appellate brief. Table of Authorities. The Table of Authorities, TOA, lists all the primary authority, like for example, cases, statutes, administrative regulations, administrative decisions, constitutional provisions, charter provisions, ordinances, and court rules, and secondary authority, like for example, legal periodical articles and legal treatises, cited in the brief. All the cases are listed in alphabetical order. All the statutes are listed in alphabetical and numerical order, etc. The page numbers on which each of these authorities is discussed in the brief are presented so that the table acts as an index to these authorities, as shown in Exhibit 10-4. The major software programs, like for example Word and WordPerfect, include built-in assistance for creating tables of authorities. Exhibit 10-4, Table of Authorities in an Appellate Brief. Quick tip: a skill that a paralegal should master is creating a table of contents and table of authorities. This skill is used not only for appellate briefs, but also for some trial-level briefs. Statement of jurisdiction. In this section of the brief, there is a short paragraph stating the subject matter jurisdiction of the appellate court. For example, this court has jurisdiction under 28 U.S.C. Statute 1291, 1997. The jurisdiction statement may also give some of the essential facts that relate to the jurisdiction of the appellate court, such as how the case came up on appeal. For example, on January 2nd, 1998, a judgment was entered by the U.S. Court of Appeals for the Second Circuit. The U.S. Supreme Court granted certiorari on February 6, 1998, 400 U.S. 302, 1998. Later in the brief, there is a statement of the case, which often includes more detailed jurisdictional information. Questions presented. The label used for the questions presented section of the brief varies. Other names for it include points relied on for reversal, points in error, assignments of error, and issues presented. Regardless of the label, its substance is essentially the same. It is a statement of the legal issues that the party wishes the appellate court to consider and decide. Standard of review. The standard of review is a critical section of an appellate brief. It is the amount of deference an appellate court gives a lower court decision or jury verdict. There are a number of different standards for review that an appellate court may consider, such as abuse of discretion, plain error, harmless error, plenary, or de novo review, to name a few. Each standard guides a court in reaching its result of the lower court decision. Statement of the case. The statement of the case has two main components. The first is a summary of the procedural history of the dispute, what has happened in the lower courts and in the current court up to the time the brief is filed. The second is a presentation of the essential facts of the case. A statement of the case may also include the basis of the appellate court's subject matter, jurisdiction to hear the appeal. Exhibit 10-5 presents an example of a statement of the case. Note that the statement provides specific page references to the trial transcript, often abbreviated TR. A transcript is a word-for-word account of something. Throughout the appellate brief, references to what occurred during the trial, like for example, the testimony of a particular witness or a motion made by counsel, should be accompanied by cites to pages of the transcript on which those occurrences are recorded. Note that some courts require the statement of the case to be separated into two sections: statement of the case and statement of the facts. This will be determined by the rules of the court in which the brief is filed. Quick tip: when preparing a statement of the case and statement of the facts, each line should have a record reference from the appendix, such as APP 101 or JA 101, which stands for Appendix or Joint Appendix. By doing this, it adds credibility to your presentation and argument before the court. Exhibit 10-5, Statement of the case and facts in an appellate brief. Statement of the case and facts. This action is based on the Federal Tort Claims Act 28 United States Code Statute 1346B, initiated by the appellants Garrett Freight Lines Incorporated and Charles R. Thomas in the United States District Court for the District of Idaho. The appellant alleged that appellee's employee, Randall W. Reynolds, while acting within the scope of his employment, negligently caused injury to appellants. The United States denied that the employee was acting within the scope of his employment. On March 27, 2008, appellant Garrett made a motion for limited summary judgment on whether Reynolds was acting with the scope of his employment when the collision occurred. JA 2001. The actions of Garrett and Thomas were consolidated by order of the court, and appellee later moved for summary judgment, JA 204. The district court held, under the authority of Bertoni v. United States, 436 F2D 1372, 9th Circuit, 1970, that Reynolds was not within the scope of his employment when the accident occurred, and granted appellee's motion for summary judgment, JA 006. It is from that order and judgment that the injured now appeals, JA 001. Staff Sergeant Reynolds was a career soldier in the United States military and, until November 9, 2005, stationed at Fort Rucker, Alabama. JA 250. On or about July 30, 2005, official orders directed that Reynolds be reassigned to Japan, which occurred on Summary of Argument. The major points to be made in the brief are summarized in this section. It is a concise summary of the brief and usually is one of the last sections to be prepared in an appellate brief. Argument. In the argument, the attorney explains the legal positions of the client. The positions are presented in the order of the point headings listed in the table of contents. The point headings are printed in the body of the argument exactly as they are printed in the table of contents. All the primary and secondary authority relied on are analyzed. Conclusion. The conclusion states what action the attorney is asking the appellate court to take. This may include asking the court to affirm, reverse, or vacate the lower court decision. This is essentially telling the appellate court the relief you want from it. Certificate of service and other certifications. At the end of the brief is a certificate of service and other required certifications. The certificate of service tells the court the method of transmission of the brief, such as electronic filing or by mail. A certificate of service is required on almost all court filings. Other certifications that may be included at the end of the appellate brief are affirmations that the attorney filing the brief is in good standing with the court, an affirmation of the word count, and virus check. Always check the court rules for the certifications required in that court. Appendices. If needed, the appendices contain excerpts from statutes or other primary authority, excerpts from the trial transcript, charts, descriptions of exhibits entered into evidence at the trial, etc. Most court rules require that a joint appendix must be filed, which means that the attorneys in the case must consult as to the contents of the joint appendix. Online exercise. Go to www.supremecourt.gov and choose a recent case that has been decided. On the website, access the briefs of the appellant and appellee, determine the issues of the case and the court from which the matter is appealed. Hint: after you pick a case, do a docket search of that case and all the entries for that case will appear. Look for the briefs of the appellants and appellees. Technology update. A technology update and the current trends in legal writing. Technology is advancing every day and faster than many of us can keep pace. In Chapter 9, the technology update focused on ChatGPT, the new AI technology, with its positives and negatives. Technology is now focusing on the editing and drafting process with such programs as Brief Catch and Word Rake. Both technologies offer advanced editing opportunities for legal writing documents. Brief Catch can be used with Microsoft's Word program, but not Apple products, and reviews legal documents for grammatical and stylistic issues. The program makes suggested edits, scores the draft, and assesses its strengths and weaknesses. The software tells the user how to correct the brief and make it better and more readable. Suggestions such as shorter sentence, less legalese, and more everyday language usage are made to refine the brief. On the other hand, WordRake is another editing software tool that focuses more on structure. It seeks to make the legal document clearer and more concise with its editing software. WordRake is compatible with Microsoft or Apple products. Other software editing programs currently available are Pro Writing Aid and Grammarly. These products are less expensive than Brief Catch and WordRake, but offer an alternative. Whether you use a software program to assist in editing your brief, always remember that you must stand by your work. Just because a software program or a human makes a suggested edit does not mean you have to accept it. When you present your work to a supervisor, you have to own it. It is your work product, which includes researching, checking citations, and editing. If something goes amiss, do not blame the program or AI, as we saw in Meta vs. Avianca Incorporated. Advancement in technology is a time saver and, in many instances, makes our work product better. Just always keep in the back of your mind that verification procedures are still required, no matter what technology you are using. Ethically, you and your supervisor are responsible for the work created. 10-9 General Writing Guidelines. Too often, legal writing is intentionally verbose and obscure to distinguish lawyers from the general public. Only another lawyer could understand the lengthy documents filled with Latin and legalese, thereby ensuring that all parties would seek legal counsel. Equally serious is the complaint that legal writing is often deficient in writing basics. In 2011, the U.S. Court of Appeals for the Seventh Circuit chastised an attorney for submitting a complaint that had rampant grammatical errors. Noting the lack of punctuation, the court in Standard v. Nigren 658 F3D 792798, 7th Circuit 2011, said that at least 23 sentences contained 100 or more words. An isolated case, not so. The court said, "We acknowledge the unfortunate reality that poor writing occurs too often in our profession." In the same year, the U.S. Court of Appeals for the Fifth Circuit in Sanchez v. Carrollton Farmers Branch Independent School District 647 F3D 156 172, 5th Circuit 2011 said, "Usually, we do not comment on technical and grammatical errors because anyone can make such an occasional mistake. But here the miscues are so egregious and obvious that an average fourth grader would have avoided most of them. For example, the word principles should have been principles. The word vacator is misspelled. The subject and verb are not in agreement in one of the sentences, which has a singular subject, incompetence, and a plural verb, are. Writing challenges are an age-old problem for the courts, with many attorneys admonished for their lack in writing skills. The Minnesota Supreme Court opines in R.E. Hawkins 502 NW2D 770 MINN 1993 that an attorney's conduct reflected not only on his client, but also on the entire legal profession. The sanction involved more than money. Order of the court, a case study in R.E. Hawkins, Supreme Court of Minnesota 502 NW2D 770 Minnesota 1993. In R.E. Hawkins involves a bankruptcy matter. The irony of the Hawkins case is that the court found the attorney knew the basic bankruptcy procedures but lacked writing skills. Patrick Hawkins was a bankruptcy attorney who had been brought up on ethics charges before. The focus of the complaints before the court dealt with Hawkins' failure to comply with local bankruptcy rules and repeated filing of documents rendered unintelligible by numerous spelling, grammatical, and typographical errors, and amounted to incompetent representation. The court listed numerous failures by Hawkins to follow the rules when filing required documents, and when he did file documents, they had errors which led to allegations of his incompetency. These errors did not harm his clients, and thus Hawkins argued that no one was harmed and thus no need for sanctions. The court thought otherwise. What Hawkins had violated in essence was the public trust in the judicial system and lawyers generally. The court sanctioned him by publicly reprimanding him and requiring him to attend CLE classes, one of which was on legal writing. Discussion questions. Examine in R.E. Hawkins. What was Hawkins' attitude toward his clients and the court? Why did Hawkins believe sanctions were not warranted? What were the sanctions imposed by the court? Were the sanctions by the court appropriate? Defend your response. 10-9A. Guidelines. Everything you write, including email messages, should meet the high standards of communication that will be expected of you as a legal professional. Here are some guidelines to help you with this objective. Most of the guidelines involve styles such as word choice. These are important, but not as important as the grammar and composition guidelines that are the basis of the core writing assignments at the end of every chapter in the book. 1. Do not use circumlocutions. circumlocution is the use of more words than needed to express something. An example is the use of a pair of words that have the same effect. Here is a list of circumlocutions commonly found in the law. Avoid using them. Pick one of the words and discard the other. Do not say, or say. Do not say any and all. Say any or say all. Do not say each and every. Say each or say every. Do not say final and conclusive. Say final or say conclusive. Do not say full and complete. Say full or say complete. Do not say over and above. Say over or say above. Do not say sole and exclusive. Say sole or say exclusive. Do not say unless and until. Say unless or say until. If language adds nothing to the sentence, don't use it. There is an easy test to find out if a phrase, clause, or sentence uses language that adds nothing. Remove it and ask yourself whether you have altered the meaning or emphasis desired. If not, keep it out. Compare these sentences in these two columns. Your maximum recovery is $100 under the provisions of the Warsaw Convention. Your maximum recovery is $100 under the Warsaw Convention. When we remove the words provisions of from the first sentence, we lose neither meaning nor emphasis, hence we don't need it. Use the language in the second column unless you have a valid reason to use the language in the first column. Don't say by means of, say by or with. Do not say due to the fact that, say because. Do not say during the course of, say during. Do not say in the light of, say because. Do not say in the time of, say during. Do not say in order to, say to. Do not say prior to, say before. Do not say provision of law, say law. Do not say state of New Jersey, say New Jersey. Do not say until such time as, say until. 2. Use shorter words when longer ways of expressing the same idea add nothing. Use the language in the second column unless you have a valid reason to use the language in the first column. Do not say adequate number of, say enough. Do not say add such time as, say when. Do not say because of the fact that, say because. Do not say during such time as, say while. Do not say enter into a contact, say contract, verb. Do not say for a period of, say for. Do not say for the duration of, say during. Do not say for the purpose, say for. Do not say for the purpose of entering, say to enter. Do not say for the reason that, say because. Do not say have need of, say need. Do not say in case, say if. Do not say in cases in which, say when. Do not say in regard to, say about. Do not say in view of, say because. Do not say is applicable, say applies. Do not say is binding on, say binds. Do not say is dependent on, say depends on. Do not say is entitled to, say may. Do not say make an appointment of, say appoint. Do not say make a determination of, say determine. Do not say provided that, say if. Do not say the question As to whether, say whether. 3. Use a less complicated or less fancy way of expressing the same idea when meaning or emphasis is not lost. Use the language in the second column unless you have a valid reason to use the language in the first column. Do not say accorded, say given. Do not say afforded, say given. Do not say afford an opportunity, say allow or let. Do not say at the time, say when. Do not say commence, say begin. Do not say endeavor as a verb, say try. Do not say expires, say ends. Do not say forthwith, say immediately. Do not say have knowledge of, say know. Do not say in accordance with, say under. Do not say is authorized to, say may. Do not say is empowered to, say may. Do not say is hereby authorized, say may. Do not say of service to, say serves. Do not say per annum, say per year. 4. Words to avoid without a good reason to use them. Abeyance, above as an adjective, above mentioned, afore granted, aforementioned, aforesaid, before mentioned, henceforward, hereby, herein, hereafter, herein before, hereunto, pursuant, said, as a substitute for the, that, or those, same, as a substitute for it, he, him, she, or her, thenceforth, thereunto, therewith, to wit, unto, whatsoever, whensoever, wheresoever, whereof, whosoever, within, named, witnesseth. 5. Use action, verbs, and adjectives. Avoid nominalizations. Avoid nominalizations, which are nouns formed from verbs or adjectives. Examples: the noun consideration from the verb consider. The noun effectiveness from the adjective effective. Nominalizations are not grammatically incorrect. In most cases, however, they weaken a sentence. Unfortunately, the legal profession is addicted to nominalizations. Avoid this addiction yourself. Note, however, that if a word or phrase is a term of art, you need to use it even if it is a nominalization or is awkward or verbose. The word consideration, for example, is a contract term that means something of value exchanged between the parties. In the following sentence, the word is used correctly. The agreement failed because of inadequate consideration. When consideration is used as a substitute for the word consider, the word is a nominalization that generally should be avoided. Weak. After consideration of the proposals by the parties, the meeting ended. Better. After the parties considered the proposals, the meeting ended. Compare the sentences in these two columns. He came to the realization that the effort is futile. He realized the effort is futile. She made the decision to retire. She decided to retire. A determination of who should pay was made by the court. The court determined who should pay. The nominalizations in column A are realization, decision, and determination. The sentences in column B use verbs realized, decided, and determined, and are more forceful and direct. The sentences in column A that use the nominalizations are more stilted and verbose. Using nominalizations often leads to longer words and longer sentences. It also encourages the use of the passive voice. In the third example, as we will see, hence, avoid nominalizations unless they are terms of art. Do not say, say. Do not say, give consideration to, say, consider. Do not say, give recognition to, say, recognize. Do not say, have knowledge of, say, know. Do not say, in the determination of, say, determine. Do not say is applicable. Say applies. Do not say is dependent on. Say depends on. Do not say make an appointment of. Say appoint. Do not say make provision for. Say provide for. 6. Use active voice. Use active voice rather than passive voice by making the doer of the action the main focus of the sentence. Compare the sentences in the following 2 columns. A passive voice, active voice. The decision, a passive voice. The decision was announced by the judge. Active voice. The judge announced the decision. A passive voice. The report will be prepared. Active voice. I will prepare the report. Passive voice. The court was cleared. Active voice. The clerk cleared the court. Passive voice. The strike was ended by the injunction. Active voice. The injunction ended the strike. By Friday, the bridge. By Friday, the will have been blown workers will have up by the workers. Blown up the bridge. By Friday, the bridge by Friday. The will have been blown. Workers will have up by the workers. Blown up the bridge. The verbs in the sentences in the A column are in the passive voice. The verbs in the sentences in the B column are in the active voice. Sentences with verbs in the passive voice have the following characteristics. The doer of the action is either unknown or given less emphasis than what was done. The doer of the action, if referred to at all, is mentioned after the action itself. The subject of the sentence receives the action. The subject is acted upon. If you do not mention the doer of the action in the sentence, the verb form is a truncated passive. In the following sentence, for example, you don't know who fired Lucas. The report will be prepared. The court was cleared. Lucas was fired at noon. Sentences with verbs in the active voice have the following characteristics. The doer of the action is the important focus. The doer of the action is mentioned before the action itself. The subject of the sentence performs the action. The subject is the doer of the action. The passive voice is often less effective because it is less direct and often less clear. It can dilute the forcefulness of a statement. Weak. It is no longer allowed to take law library books overnight. Better. The law library no longer allows you to take books overnight. Or, the law library no longer allows students to take books overnight. The action in these sentences is the prohibition on taking books overnight. In the rewrites, we know who has performed this action, the law library. In the first sentence, we are not sure. The subject and center of attention in the rewrites is the law library. The subject and center of attention in the first sentence is the prohibition, the action. Of course, there are times when a speaker or writer wants to hide behind the haziness of the passive voice. A glaring example is when politicians are charged with improprieties and respond with vague, generalities. Mistakes have been made. 7. Use positive statements. Phrase something positively rather than negatively whenever possible. Do not say, say. Do not say, it is not difficult to imagine. Say, it is easy to imagine. Do not say, the paper is not without flaws. Say, the paper has flaws. Do not say, whenever possible, replace a negative phrase with a single word that has the same meaning. Do not say not able. Say unable. Do not say not accept. Say reject. Do not say not certain. Say uncertain. Do not say does not have. Say lacks. Do not say does not include. Say excludes or omits. Do not say not many. Say few. Do not say not often. Say rarely. When asked about the questionable fundraising activities of a supporter, President Bill Clinton said, "I had no reason to believe that he didn't know what the law was and wouldn't follow it." Alternatively, the president could have said, "I expected him to follow the law." 8. Use shorter sentences. There is no rule on how long a sentence must be. In general, however, the longer a sentence is, the more difficult it is to follow. Although readers are able to understand most long sentences, such sentences tend to tax the patience of readers unduly. As a general guideline, try to avoid sentences longer than 25 words. Some authorities are even stricter. Judge Arthur Gilbert, for example, says if a sentence has more than 20 words, it usually needs to be redrafted. Unfortunately, sentences are almost always too long in legal writing. Here's an example from a legal memorandum. In the rewrite, we have broken a 57-word sentence into 4 smaller, more readable sentences. Weak. Claims for child support were not fully and finally adjudicated pursuant to a North Carolina divorce judgment, where the North Carolina court did not have personal jurisdiction over the husband and could not adjudicate any child support claims without this kind of jurisdiction, and therefore Florida is not precluded from collecting monies from the husband toward arrearages. Better, the North Carolina divorce judgment did not fully and finally adjudicate the claims for child support. The reason is that the North Carolina court did not have personal jurisdiction over the husband. It could not adjudicate child support claims without this jurisdiction. Florida is therefore allowed to collect monies from the husband toward arrearages. Other examples. Weak. In May of 2023, a district personnel administrator informed Mary Miller that the district had decided to transfer Mary to a different school, which was a decision that was based on information Miller provided. However, the administrator had never talked to Miller in person prior to the decision. Better, in May of 2023, a district personnel administrator informed Mary Miller that the district will transfer Mary to a different school. The district based its decision on information Miller provided. The administrator, however, never talked to Miller in person prior to the decision. Week. The new job at the firm as the legal administrator in charge of personnel and finances was enjoyable, lucrative, educational, and challenging, but confusing and frightening at times. Better. The new job at the firm as legal administrator in charge of personnel and finances was enjoyable, lucrative, educational, and challenging. At times, however, it was also confusing and frightening. Week. The final issue for discussion concerns the status of the national and international parties. That has been the main stumbling block in the contract negotiations thus far. Better. The final issue for discussion is the status of the national and international parties. This issue has been the main stumbling block in contract negotiations thus far. 9. Be careful with pronoun references. Avoid pronouns, like for example, he, she, it, they, unless the nouns to which the pronouns refer are clear. Using pronouns with ambiguous reference can confuse the meaning of a sentence. If the pronoun could refer to more than one person or object in a sentence, repeat the name of the person or object to avoid ambiguity. Do not say, after the administrator appoints a deputy assistant, he shall supervise the team. Who does the supervising? The administrator or the deputy. If the latter is intended, then say, after the administrator appoints a deputy assistant, the deputy assistant shall supervise the team. When a writer uses pronouns, their antecedents, what the pronoun stands for, must be clear. 10. Avoid sexism in language. Avoid gender-specific language when the intent is to refer to both sexes. If neutral language is not available, rewrite the sentence to avoid the problem. Gender-specific language, gender-neutral alternatives. Gender-specific language, actress, gender-neutral alternatives, actor. Businessman, executive, member of the business community. Gender-specific language, chairman, gender-neutral alternatives, chairperson, chair, moderator, head, presiding officer. Gender-specific language, clergyman, gender-neutral alternatives, minister, priest, rabbi, member of the clergy. Gender-specific language, fireman, gender-neutral alternatives, firefighter. Gender-specific language, mankind, gender-neutral alternatives, humanity, human race, people. Gender-specific language, policeman, gender-neutral alternatives, officer, police officer. Gender-specific language, mailman, gender-neutral alternatives, letter carrier, postal worker. Gender-specific language, salesman, gender-neutral alternatives, seller, sales representative. Gender-specific language, reasonable man, gender-neutral alternatives, reasonable person. 11. Follow the rule of parallelism. Parallelism means using a consistent parallel. Parallelism means using a consistent grammatical structure when phrasing logically related Parallelism means using a consistent grammatical structure when phrasing logically related ideas in a list, i.e., important example, parallel. Parallelism means using a consistent, i.e., important example, parallel, grammatical structure when phrasing logically related ideas in a list. The following sentence is not parallel because the list uses two ing words, driving, skiing, and one infinitive, to read. The doctor enjoys driving, skiing, and to read. Corrections that make the sentence parallel. The doctor enjoys driving, skiing, and reading. The doctor likes to drive, ski, and read. The following sentence is not parallel because the list contains two clauses in the active voice and one in the passive voice. The attorney expected to present the case to the jury, making closing arguments and have questions asked of him. Corrections that make the sentence parallel. The attorney expected to present the case to the jury, making closing arguments and answer questions. Not parallel. The nationalities of reporters in the room consisted of the French and Russians, Spanish, and there were Greeks. Corrections that make the sentence parallel. The nationalities of reporters in the room consisted of the French, the Russians, the Spanish, and the Greeks. The nationalities of reporters in the room were French, Russian, Spanish, and Greek. 12. Use everyday language. In the 1970s, the plain English or plain language movement began with the goal of adding greater clarity to our written communication, particularly commercial and government communication. The federal government and more than half the states passed laws requiring certain documents, like, for example, insurance contracts and securities disclosure statements, to be written in everyday language. In general, the components of everyday language are those that we have been discussing in this chapter. Avoid long sentences. Use the active voice rather than the passive voice. Use strong verbs rather than nominalizations. Avoid superfluous words. Phrase things positively. Avoid multiple negatives. Some of the laws impose a readability level based in parts on the number of words used in sentences or the average number of syllables per word. The lower the number of words a document uses in its sentences, on average, the better the overall readability score the document will have. Readability refers to the ease with which someone can read a passage. One way to force writers to use shorter sentences is to mandate that the document have a specified readability score. The Plain Language Consumer Contract Act contains guidelines. The Plain Language Consumer Contract Act contains guidelines a court must consider when determining whether a contract is written in everyday language. Here, for example, are the guidelines for contracts in Pennsylvania. 1. The contract should use short words, sentences, and paragraphs. 2. The contract should use active verbs. 3. The contract should not use technical legal terms, other than commonly understood legal terms, such as mortgage, warranty, and security interest. 4. The contract should not use Latin or foreign words or any other words whenever its use requires reliance upon an obsolete meaning. 5. If the contract defines words, the words should be defined by using commonly understood meanings. 6. The contract should not use sentences that contain more than one condition. 7. The contract should not use cross-references, except cross-references that briefly and clearly describe the substance of the item to which reference is made. 8. The contract should not use sentences with double negatives or exceptions to exceptions. Everyday language laws do not apply to most of the kinds of writing prepared in a law office, such as a memorandum of law or appellate brief. The laws are designed to help citizens understand written materials prepared by governments and by businesses. Yet, the writing principles proposed by the plain English movement can be applied to any writing. It would be a high compliment to say of any document prepared by an attorney or paralegal, particularly a document that covers complex legal material, that it was written in everyday language. Online exercise. Determine whether your state has a statute requiring legal documents, such as consumer contracts, be written in everyday language. 13. Avoid spelling and usage errors. The best way to overcome commonly misspelled words is to memorize the correct spelling. Look it up in a dictionary or use spell check in your document preparation program, such as Word or WordPerfect. If you are using a software program, many spelling errors will be identified, but unfortunately not all. Many words are not only misspelled, but are misused because of that misspelling. Think of effect and effect, illicit and illicit, advise and advice, insure and insure, principle and principle, to name a few. Sometimes the misspelling or misuse is simply because of rushing, and when you go back and check or proof your work, you just shake your head. Slow down and review your work before you turn it in to your supervisor. It will save for some embarrassing moments. 14. Review the punctuation. How we use punctuation, such as the period, comma, or semicolon, can determine the meaning of a sentence, term, or condition in a legal document. Knowing how to use punctuation is an important skill in drafting and preparing a legal document. Some punctuation guidelines to follow include the following. Comma. Commas are used to separate thoughts, set off a series, or create pauses in a sentence. Use a comma in a series of 3 or more terms, before a conjunction such as because, and after transitional phrase such as however or consequently. Apostrophe. Use the apostrophe to show possessiveness or contractions, such as Blake's son hit a home run at the game. With a contraction, the apostrophe takes the place of omitted words. For example, cannot is substituted with can't. However, in legal writing, stay away from using contractions. One of the most misused and misstated contractions in possessive pronouns is the word its or its. Its is the contraction it is, while its is the possessive and does not use an apostrophe. To remember which is correct, simply say it is in the sentence. If it does not make sense, then you should be using its, the possessive pronoun. For example, the committee abused its or its power when ruling on the permit. The correct use is its without the apostrophe. Say the sentence aloud with it is. The committee abused it is power when ruling on the permit. Saying it is in the sentence makes no sense. This is an easy way to remember which word to use. Semicolon and colon. Semicolons usually join two independent sentences that are independent but related. On the other hand, a colon is used to introduce information, such as a list or quotation. Hyphen and dash. Hyphens are used to connect to words, such as pre-war. It is the short line that is used to join two words or compound words. Father-in-law. However, a dash, which is the longer line used in the previous sentence and is used for emphasis or set off a part of a sentence. Like this, quotation mark. Quoting material that supports a legal position is common in legal briefs. Quotation marks are used to indicate that cited material is usually followed by a citation reference. The general rule is when citing material that is more than 50 words, 3 to 4 lines, indent the quoted material with a single space and without quotation marks. A significant debate regarding quotation marks is where to place punctuation. Inside or outside of the quotation marks. Here are the general rules to follow. Punctuation, quotation mark punctuation. Punctuation, period, quotation mark placement. A quotation mark is placed after a period. Punctuation, comma. Quotation mark placement. A quotation mark is placed after a comma. Quotation mark. A quotation mark is placed after a quotation mark. Punctuation, semicolon, quotation mark placement. A quotation mark is placed before a semicolon. Punctuation, colon, quotation mark placement. A quotation mark is placed before a colon. Grammar saves lives. Finally, examine how punctuation in the following sentences dramatically changes the meaning of the sentence. The last example proves that good grammar can save lives. The defendant said the witness lied. The defendant said the witness lied. Women without her man is nothing. Women without her man is nothing. Let's eat, Grandma. Let's eat, Grandma. Punctuation counts and sometimes can be the center of a legal dispute. Does the placement of a comma, semicolon, or period matter? In Sullivan v. Abraham 488 SW3D 294 Text 2016, the court had to determine how punctuation affected a legal dispute regarding attorney's fees. Order of the court, a case study. Sullivan v. Abraham, Supreme Court of Texas 488 SW3D 294 TEX 2016. At issue in Sullivan v. Abraham was the interpretation of a statute and the use of commas. Abraham sued Sullivan for defamation. Sullivan filed a motion to dismiss under the Texas Citizens Participation Act, TCPA. Under the Act, if the party is successful in having the case dismissed by the court, that party is entitled to attorney's fees, costs, and imposing sanctions sufficient to deter similar future actions. Sullivan won his motion to dismiss, and the trial court awarded $6,500 in attorney's fees and $1,500 in costs, and stated that justice and equity necessitate defendant's recovery of reasonable attorney's fees. Sullivan challenged the award as inadequate, as he initially requested $67,290 in attorney's fees and $4,381.01 in costs and expenses. The appellate court affirmed the monetary reward, but remanded the case to determine if sanctions were mandatory under the statute. The court further found that justice and equity permitted the trial court discretion in the amount of the attorney's fees awarded, and focused on a case dealing with declaratory judgment act and applying its analysis. Sullivan appealed that decision. The Texas Supreme Court had to determine what was considered reasonable attorney fees under the Texas Citizens Participation Act, TCPA. The section stated, if the court orders dismissal of a legal action under this chapter, the court shall award to the moving party 1. Court costs, reasonable attorney's fees, and other expenses incurred in defending against the legal action a justice and equity may require, and sanctions. ID Statute 27.009A. At issue was whether reasonable attorney's fees also include those that justice and equity may require. The focus was the placement of the comma after the words reasonable attorney's fees, relying on a secondary source from Antonin Scalia and Brian A. Garner. Reading law. The interpretation of legal texts 147/2012. The court looked at the placement of the words modified, and the punctuation used in the statute. The court went into a detailed analysis and discussed the placement of the comma in the statute, and stated that since the comma was placed before the word and the statute does not include a comma after other expenses or after legal action, and their absence indicates an intent to limit the justice and equity modifier to the last item in the series. The court spent several pages discussing the placement of the comma in the words modified and a discussion of the Oxford comma. The Oxford or serial comma is the comma placed immediately before the coordinating conjunction in a series of 3 or more terms. ID at 298. As the court noted, although the use of the Oxford comma is not definitive, we agree that its use here, together with the inclusion of the word other and the absence of the other comma, indicate the legislature intended to limit the justice and equity modifier to other expenses. Based on the court's review of the law and grammar points, it stated that the language of the TCPA required an award of reasonable attorney's fees, one that is not extreme or excessive, but rather moderate or fair. What the court continued to say was that the award did not include considerations of justice and equity. Thus, since the lower court's decision included justice and equity as part of their analysis and not simply reasonableness, the courts erred in the award of the attorney's fees to Mr. Sullivan, based on the interpretation of what reasonable attorney's fees means and how it should be calculated. The Texas Supreme Court remanded the case to the trial court to determine an award of fees based on the appropriate standard. Discussion questions. Examine Sullivan v. Abraham. What case did Abraham argue should be the standard for determining reasonable attorney's fees? Why did the court reject Abraham's position? What arguments did Sullivan and Abraham advance in support of their positions on the interpretation of the statute? Why was the positioning of the comma in the TCPA important? Was the result fair and just for the parties? Defend your response. 16. Editing and rewriting legal documents. An essential element of legal writing is editing and rewriting. Attorneys are known for many iterations of a legal document. Edit for content, punctuation, grammar, sentence structure, and readability. Make sure your language is precise and clear. Don't use too much legal terminology such as legalese, if everyday language will do. Be critical when you are editing. Make every word count. Part of editing is rewriting. Rarely is a draft of a document its final version. Editing and rewriting is part of refining your work product. It will make your final product better. Some guidelines in legal writing include the following. Understand the purpose of the assignment. Ask questions and know your deadlines. Find a template, sample, or model to follow that is similar to your assignment. Outline the contents of the document you want to create. Research the law. Shepherd key cite and check citations for accuracy. Modify and draft the template, sample, or model to comport with the requirements of your assignment. Determine if any court rules apply to the document being drafted. Review the draft document for spelling, grammar, punctuation, sentence construction, and accuracy. Edit, proofread, edit, rewrite, proofread, and edit some more. Submit final document for review by supervisor. See Exhibit 10-6 for a summary of preparing a legal writing assignment. Exhibit 10-6, Summary of Preparing a Legal Writing Assignment. Objectives in legal writing assignments. What are the goals of the assignment? Draft document, research the law, other. Timeline. What are the deadlines for the assignment? Are deadlines imposed by court or attorney? Form of assignment. In what format should the assignment be presented? Are there forms, templates, or examples to follow? Documentation. What documents, if any, are required to complete the assignment? Is all information for the assignment readily available? Communication. Are there ways to communicate questions to the supervisor? Do I have cell phone information of supervisor if needed? Final product. Have citations been checked? Has document been reviewed? Edit and proofread for grammar, spelling, and punctuation. Real-world perspectives. On-the-job observations. In our paralegal perspectives, we have two paralegals from different specialty areas who draft legal documents and interact with clients. Their days are filled performing varying functions, as we will see first from a probate paralegal and second from a bankruptcy paralegal. The position can be very stressful, but it is seldom boring. My typical day involves responding to many telephone inquiries from clients, writing memos or letters requesting additional information concerning life insurance policies, valuation of assets, or simply sending notices of an upcoming hearing to all persons entitled, etc. I draft virtually all documents needed in the administration of an estate, beginning with the initial petition for probate. The descendant may have had an interest in a closely held business, or leave minor or handicapped children, or leave a spouse with no knowledge of the family assets. These all require additional attention. Every case is different. Probate paralegals, to some extent, must be snoopy, because you do learn a great deal about people, both deceased and living. In most cases, your client is facing a difficult time with trepidation, and it is your role to provide confidence. The end results are very rewarding. Rose, still a probate paralegal. 12, the Journal 5, Sacramento Valley Paralegal Association. And our bankruptcy paralegal is immersed in the process, as is noted. Here, the paralegal has much latitude and prepares many of the substantive documents required in a case. Bankruptcy work is unusual in a number of ways, like, for example, extremely short statutes of limitation. The paralegal does everything except sign the papers. Johnson, the role of the paralegal and legal assistant in bankruptcy and foreclosure. AALA News 7 Alaska Associations of Paralegals. Chapter Review 10-10A Chapter Summary. Introduction. 1. Legal writing is critical in the practice of law. The phrase legal writing can refer to preparing documents that require legal analysis or legal research. It can also refer to special formats for legal documents and general communication techniques for any kind of writing. 2. When given a writing assignment, determine basics such as the audience, due date, models to use, and availability of resources and feedback before the due date. 3. Proofreading should allow you to spot typos, spelling errors, grammar errors, and format inconsistencies. Some of the major techniques of self-proofreading include reading a hard copy of the draft, reading it aloud to yourself and to another person, reading it in a different font and point size, and reading it backward. Dangers of copy and paste. The two main dangers of copy and paste writing are plagiarism, the failure to cite sources, and style inconsistency. The text pasted in does not adequately conform. The text pasted in does not adequately conform to the style of the writing into which it is copied. Types of legal writing. Documents used in the legal profession. 1. Law offices often write traditional letters, emails, pleadings, instruments, memoranda of law, and appellate briefs. The standard components of most letters are heading, date, method of delivery, recipient, RE, salutation, body, and closing. Letters can also include notations for enclosures and the initials of the typist. 2. A cover letter states what is being sent in the same envelope or package, and often the reason for sending it. A demand letter is an advocacy letter that asks the recipient to take or refrain from specific action affecting the client. An informational letter provides or seeks information. A status letter updates someone on a matter. A confirmatory letter verifies or confirms that something important has been done or said. An opinion letter is a letter to a client explaining the application of the law and providing legal advice based on that explanation. Email writing. Email writing requires conformity to office policy on email communication, like, for example, the use of encryption, the formality of a business letter, the absence of special formatting, correct spelling and grammar, and indication of non-attorney status. If the writer is not an attorney. Email writing also requires caution in tone, care to avoid sending the email to the wrong person, care to avoid virus contamination, and careful proofreading. Drafting legal documents and pleadings. 1. Instruments are written documents that give expression to or embody a legal act or agreement, like, for example, a contract, deed, will, lease, or mortgage. Pleadings are formal litigation documents filed by a party that state or respond to the claims and defenses the party have against each other. The main pleadings are the complaint and the answer. 2. The starting point in drafting instruments and pleadings is often a standard form or template that is available on software, in form books, or in old case files. The memorandum of law or legal memorandum is a written explanation of how one or more rules might apply to the facts of a client's case. 3. An appellate brief is a document that a party files with an appellate court and serves on an opponent, in which the party presents arguments on why the appellate court should affirm, approve, reverse, vacate, cancel, or otherwise modify what a lower court has done. The major components of many appellate briefs are caption, table of contents with point headings, table of authorities, statement of jurisdiction, questions presented, standard of review, statement of the case, summary of argument, conclusion, certificate of service with required certifications, and appendices. Most rules require that attorneys confer about the contents of appendices and prepare a joint appendix. The general writing guidelines. 1. Writers that follow a number of important guidelines will increase the clarity and effectiveness of any kind of writing. Avoid circumlocutions and nominalizations. Use shorter and simpler words when possible. Use action verbs and the active voice, and express something positively whenever possible. Additionally, avoid long sentences, make pronoun references, their antecedents clear, avoid sexist language, follow the rule on parallelism, use everyday language, spell correctly, and obey all grammar rules, including the proper use of punctuation. 2. Editing and rewriting any legal writing assignment is an important component of the process. Know that legal writing often encompasses many drafts before the final product is approved. 3. As with legal research, you must have a plan. By creating a plan, you will have an organized approach to all legal writing assignments, regardless of the assignment given. Chapter Review 10-10B. Key Terms: public domain, demand letter, informational letter, status letter, confirmatory letter, opinion letter, templates, trial notebook, brief bank, reply brief, point headings, table of authorities, TOA, questions presented, statement of the case, transcript, circumlocution, nominalizations, active voice, passive voice, truncated passive. Chapter Review 10-10C. Review questions. 1. What general guidelines should be followed when receiving any writing assignment in a law office? 2. What are the goals of proofreading and some of the major techniques of self-proofreading? 3. What are the 2 dangers of copy and paste writing? 4. Name 6 categories of writing that law offices often prepare. 5. What are the standard components of most letters? 6. What is a cover letter, demand letter, informational letter, status letter, confirmatory letter, opinion letter? 7. What are some of the major guidelines for email communications? 8. What is an instrument, pleading, memorandum of law? 9. What is an appellate brief, and what are the major components of an appellate brief? 10. What are some major guidelines for all writing? 11. What is the distinction between active and passive voice, and which should be used in legal writing? 12. List the different uses of punctuation in legal writing. 13. What is parallelism? 14. Why is editing and rewriting important in legal writing? 15. Summarize the guidelines that should be used in preparing a writing assignment. Chapter Review 10-10D Assignments Critical Analysis 10.1 How do you react to the student who says, "I am here to learn the law, not grammar"? Projects 10.2 Find a recent amicus brief filed in the U.S. Supreme Court. Find 3 examples of the passive voice within the brief. Rewrite each of the 3 sentences containing the passive voice so that the passive voice is turned into the active voice. Don't just remove the passive voice, turn it into the active voice. Chapter Review 10-10E Core Skills Assignments. Core Skill Writing 10.3 Prepare a letter for each of the following situations. You will need more facts to complete the letters, like for example, the address of the recipient, your address, and more details on the purpose of the letter. You can make up any of these facts as long as they are reasonably consistent with the facts provided. In each case, your supervisor is an attorney who wants you to draft the letter for their signature. A. The office represents Richard Clemens, who is a plaintiff in an automobile accident case against George Kiley. The latter's insurance company has offered to settle for $10,000. Draft a letter to Richard Clemens in which you tell him about the offer and ask him to call the office to schedule an appointment with your supervisor to discuss the offer. Point out that the supervisor is not pleased with the low amount of the offer, but that the decision on whether to accept it will be entirely up to the client. B. Draft a letter to a client who failed to appear at 2 meetings last month with her attorney, your supervisor, at the office to discuss her case. The client is Diane Rolark. She is very wealthy. The office hopes to keep her as a client in the future on her other cases. Hence, the office does not want to antagonize her. The letter should remind her of the next appointment with her attorney 3 weeks from today. C. Write an opinion letter to a client, James Duband, in which you explain any legal concept that you have learned in another course. Assume that this concept is relevant to the case of this client and that the client has written the office asking your supervisor to explain the concept as it pertains to his case. The client is a construction worker who never finished high school. 10.4 Rewrite any of the following sentences that contain language that can be simplified without interfering with the meaning or effectiveness of the sentence. A. You are required to pay the fine. B. The period of time you have to render assistance is 3 months. C. For the duration of construction, it shall be unlawful for a person to enter or to attempt entry. D. If you are unable to enter a contract with him for the materials, the oral commitment is still binding on you. E. She consulted with a lawyer with respect to possible litigation. F. She accepted the appointment due to the fact that she was qualified. G. It is green in color. H. Ask the witness questions about the bills. I. Judge Jones is currently on the bench. 10.5 Rewrite any of the following sentences that use the passive voice. If you need to add any facts to the sentences to identify the doer of the action, you may make them up. A. Examinations are not enjoyed. B. No drugs were prescribed after the operation. C. It has been determined that your license should be revoked. D. Consideration is being given this matter by the attorney. E. It is believed by district officials that the expense is legal. F. The fracture was discovered by the plaintiffs in 2020. G. As the semester came to a close, the students prepared for their exams. 10.6 Rewrite any of the following sentences that are too long. A. A short time later as George approached the intersection of Woodruff and Fuller, someone in the middle of the street started shooting. But George kept driving when he heard about 15 shots that sounded like different guns firing, one of which hit his SUV, damaging the front windshield and dashboard. B. By way of illustration, musician Paul McCartney and basketball player Michael Jordan arguably may have achieved such pervasive fame as to have become public figures for all purposes, while Dr. Jack Kevorkian may have voluntarily placed himself into the public controversy over euthanasia and physician-assisted suicide, so as to have become a public figure for a limited range of issues. C. The board can, within 60 days of the receipt of a certification from the Secretary, take action to return ownership of property to people or corporations certified as owners from whom the property was acquired by expropriation or by purchase under threat of expropriation. 10.7. Correct the following sentences for grammatical errors. A. If you're not sure, can we call your contact at the department? B. Do you know whether or not there is warranties for the installing of the equipment? C. Please assure that action items from last meeting is shared with respective directors. D. Here's my initial comments. E. Why did the court exercise its discretion in the case dealing with the evidentiary issues but no the procedural ones? Core skill research. 10.8. Write a memorandum in which you describe what is meant by everyday language and the efforts to promote or require everyday language in your state. Core skill. Ethics. 10.9. For a client in 2021, James Donovan prepared a memorandum in support of a motion to dismiss. The fee for preparing the memorandum was $1,000 based on 3 hours of work. In 2023, Donovan has a different client who needs a memorandum in support of a motion to dismiss in the same kind of case as the 2021 case. To use the 2021 memorandum for the 2023 client, Donovan changes the names and dates on the 2021 memorandum. This takes 10 minutes. Donovan charges the 2023 client $1,000 for preparing the memorandum. Is this ethical? What sections of your state's ethics code apply to this question? See Chapter 1 on the ethics code of your state, Chapter 6 on ethics and fees, and Appendix C on ethics in your state. Core skill. Computers. 10.10. In Google, Bing, or Yahoo search, create table of contents for appellate brief. Identify the steps in creating a table of contents. A. Write a memorandum in which you describe how to prepare the table of contents for an appellate brief. The memorandum must document which sites you consulted to locate your information. B. In the computer terminology in the law CTL notebook you started in Chapter 1, enter any new terms that you learned by doing parts this exercise. Core skill, collaboration. 10.11. Write one paragraph on any topic. The paragraph must have at least 7 sentences. The writing must be your own. Do not copy any text found online or any other source. Send your paragraph to another student in the class and ask that student to send his or her paragraph to you. If that student has already received someone's paragraph, try another student. A. Subject the other student's paragraph to Fog Index. See www.readabilityformulas.com/gunning fog readability formula.php. Also enter this search in Google, Bing, or Yahoo. Fog Index Readability. Send your Fog Index result to the writer. The result will assess the difficulty of reading your passage as measured by the grade level a reader would need. A score of 11, for example, means that a reader would need at least an 11th grade education to understand your passage with relative ease. B. When you receive the score for your paragraph, rewrite it in order to obtain a score that would improve readability. Run the fog index test on your revised paragraph. C. Send your revised paragraph and new score to the other student who scored your original paragraph. Ask them if they have any suggestions on how you could improve the readability of the paragraph even more. Summary. You will 1. Exchange paragraphs with another student. 2. Use the fog index to score the readability of the other student's paragraph. 3. Send the score to the other student. 4. Rewrite your paragraph when you receive your score. 5. Score your rewritten paragraph. 6. Send your revision and score to the other student. And 7. Provide the other student with suggestions on how they could improve their score even more. The job search. 10.12. Use the job links in Chapter 2 or use www.indeed.com or www.linkedin.com to search for paralegal jobs or job descriptions that mention any kind of writing that is part of the job. Find a variety of such jobs and descriptions. Write a memorandum in which you summarize what you find. Mention kinds of writing and writing skills that are used or required. In addition to the job sites, in Chapter 2, search in Google, Bing, or Yahoo, large law firm AA, substituting your state for AA. Check the websites of several large firms to see if they mention any of the paralegals on staff and if there is any mention of writing that the paralegals do. On the home page of a law firm site, click words such as careers, employment, join us, opportunities, people, or any other words that invite the viewer to learn about personnel at the firm. Chapter Review 10-10F Portfolio Binder Assignment. Using the facts from the beginning of Chapter 9 and the research performed about the client who had a DUI from Chapter 9's portfolio assignment, prepare the memorandum of law for review by your supervising attorney, instructor. Place in your portfolio binder. Remember to use the law from your jurisdiction, state, where possible. Look to other jurisdictions for persuasive authority to enhance your argument if no law supports your position from your state. Public domain. Work product or other property that is not protected by copyright or patent, a status that allows use by anyone without fee. Demand letter. An advocacy letter that asks the recipient to take or refrain from specific action affecting the client, like, for example, to compensate the client for harm allegedly caused by the recipient. Informational letter. A letter that provides or seeks information. Status letter. A letter that updates someone on a matter. Example, telling a client what has happened in the case thus far and what next steps are expected. Confirmatory letter. A letter that verifies or confirms that something important has been done or said. Opinion letter. A letter to a client explaining the application of the law and providing legal advice based on that explanation. Templates. Files containing text and a format that can be used as the starting point for creating frequently used documents. Trial note. A collection of documents, arguments, and strategies that an attorney plans to use during a trial, also called trial binder. Brief bank. A collection of appellate briefs and related documents drafted in prior cases that might be adapted for current cases and used as models. Reply brief. An appellate brief of the appellant that responds to the appellate brief of the appellee. 2. Any appellate brief that responds to an opponent's appellate brief. Point headings. Conclusions that a party wants a court to accept on one of the issues in the case. Table of Authorities, TOA. A list of primary authority, like for example, cases and statutes, and secondary authority, like for example, legal periodical articles and legal treatises that a writer has cited in an appellate brief or other document. The list includes page numbers where each authority is cited in the document. Questions presented. A statement of the legal issues in an appellate brief that party wants the appellate court to resolve. Statement of the case. The portion of an appellate brief that summarizes the procedural history of the case to date and presents the essential facts of the dispute. It may also state the appellate court's subject matter jurisdiction. Transcript. A word-for-word account of what was said, a written copy of what was said. Circumlocution. The use of more words than are needed to express something. Nominalizations. A noun formed from a verb or adjective. Act active voice. The grammatical verb form in which the subject or thing performing or causing the action is the main focus. Passive voice. The grammatical verb form in which the object of the action is the main focus. The emphasis is on what is being done rather than on who or what is performing or causing the action. Truncated passive. A form of passive voice in which the doer or subject of the action is not mentioned.